Coming to you from the Forge of Freedom studio in the heart of America. A podcast dedicated to preserving freedom and inspiring personal success. Freedom is born and lives through you, the individual, and it dies in the shadows of tyranny. Motivating our listeners to become well-rounded, freedom-minded people with the body of an athlete, the mind of a stoic, and the spirit of a warrior. The tree of liberty lives on through you, the Forge of Freedom. And now here's your host, Alex Ooley.
Hello, everyone, and welcome to the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 26 of the Forge of Freedom. I've got attorney and firearms instructor Mike Ooley back in the studio with me today for Monday Gun Day. Welcome back, Mike.
Hey, good morning.
Today we're going to follow up our discussion from last week about the ATF final rule regarding pistol stabilizing braces. But this week, we're going to provide an update with respect to some movement that took place this week in a case seeking an injunction against the ATF final rule in the Fifth Circuit Court of Appeals. And the case that we're referring to here is Mock v. Garland. So I think before we get started, maybe we can just recap, and if listeners want some more detail about the NFA and what's a short barrel rifle, what's a pistol, etc., maybe we can point them to our episode from last week, and I'll link to that in the show notes. But I think it might be useful here just to kind of recap on that. Mike, you want to say a little something just to kind of recap what the NFA does, what it regulates, and what requirements are associated with NFA arms?
Yeah, just to recap, the NFA dates back to 1934, and it's got a lot of onerous regulatory and mother may I, what I call them, stipulations with respect to the ownership of particular firearms. They require an NFA item, and we'll get to that in just a little bit. That's what we're talking about here today. Potentially requires registration with the federal government, a background check, send in fingerprints, basically saying, mother, may I own and possess this firearm. It also requires, although the ATF has generously agreed, I don't know if they have the authority, but agreed to waive the normal $200 tax per item that's generally associated with NFA or National Firearms Act firearms. So anyway, there are other regulatory burdens, assuming the...
But they're only waiving that for these pistol brace equipped arms.
Yeah, for this particular situation. And then if the ATF, obviously, I'm not fond of this, but if the NFA does, quote, allow you, end quote, to possess this NFA item, after that, you still have to follow the regulatory requirements in terms of transportation of the firearm. If you want to take it across state lines, you've got to do another mother may I form you have to file with them. So there are lots of regulatory requirements that severely burden your Second Amendment rights with respect to NFA firearms. Now, just briefly, generally speaking, the NFA does not regulate handguns. They don't use the word pistol, but don't regulate handguns, although originally they intended to in 1934, but that was dropped. They don't regulate handguns and rifles, generally speaking, with a barrel of length of 16 inches or more. There are other requirements as well. But so the problem we have with respect to these NFA braces or these pistol braces is whether or not you put one of these pistol braces on a firearm, whether it becomes a short-barreled rifle, which is subject to the regulations of the National Firearms Act, or whether it remains a handgun as attended by the manufacturer or not. And the other thing is that historically, I guess that's the proper word, since probably 2012 or so, the ATF and the federal government was telling us that these braces placed upon firearms did not make these firearms short-barrel rifles subject to NFA regulations. They were, in fact, handguns not subject to the NFA. But lo and behold, when the Biden administration was reportedly elected, the ATF changed their tune and decided that all of a sudden, after many years of taking a contrary position, these firearms are now supposedly short-barreled rifles and subject to the NFA.
Yeah,
So that's where we're at this juncture.
and the law didn't change, right? The ATF simply changed their interpretation of the law with respect to these firearms equipped with a pistol stabilizing brace, right?
Yeah, they've promulgated a rule which has redefined these firearms in terms of the type of firearm they are, and they've given us the rule was passed, and they've given us until May 31st of this year, 2023, to come in compliance with the rule, with what a lot of people characterize as an amnesty period. And there are certain compliance options that the ATF has given us to allow us to come into compliance with this new rule.
Yeah, and we'll get into those, highlight those options here. We talked about those in more detail last week, but we're going to briefly highlight those here in just a moment. But what's so important here about the point you were making is that for over a decade, the ATF has said if you have a firearm equipped with one of these pistol stabilizing braces, it's not an arm that's regulated by the NFA. It's
Correct.
not something that you have to register. It's not something that you have to pay a $200 tax to get a tax stamp to possess. So nobody knows exactly, but between 3 and 40 million people own these sorts of arms and purchased them with the understanding that they were not NFA regulated firearms. Is that about right?
That's right. So even if you use the low end of 3 million, it's amazing how many folks this rule has affected and will affect in the future.
And so that's what brought about a lot of the litigation that's been floating around in the federal courts, challenging the ATF's final rule, that the change of their interpretation of the law. So we're going to get into that here in just a moment. But real quickly, Mike, you want to highlight what the options people have with respect to trying to comply with this new rule?
Yeah, you might want to go back and look at our podcast or presentation from, I think, a week ago. We went into these in more detail, but just real quickly, here's the options that the ATF says that you have. First, you could submit through their eForms portal an application to make and register a firearm, and you need to do that before May 31st. It's an eForm 1. You can go to ATF, just Google or DuckDuck or whatever you do, ATF pistol rule, and it'll take you to the ATF website where you can begin that process. I'd caution you, that's not something you can do at the last minute in 5 minutes. It takes some time. You're going to have fingerprints, passport size photos, that sort of thing. And keep in mind, if you already have an NFA, if you have a trust of some sort, there are additional complications there too, in terms of proving that the firearm was in the trust prior to adoption of the rule. But anyway, that's one thing one possibility is to go through the registration process. Like I said earlier, if you do it before May 31st, you don't have to pay the $200 tax if that's important to you. The other thing is that you can remove the short barrel and attach a 16-inch or longer rifle barrel to the firearm. And then the ATF, at least as of now, says that removes it from the provisions of the NFA. You can turn your firearm into the local ATF office, or you can destroy your firearm. And once again, I would refer you to the ATF website for what you need to do if you want to follow one of those options. Probably the option that a lot of people are talking about. There are some people that are registering. I'm not sure what the numbers are. A few days ago, I read somewhere that I think was relatively credible, indicating we're in the 125,000 to 150,000 count in terms of the folks that have already begun the registration.
But remember, that sounds like a lot, but there are between 3 million and 40 million of these devices out there.
Yeah. So from what we know, it's a very small percentage of folks that have begun the registration process through the eForm portal. Now, maybe folks are waiting to see what happens with some of these court cases. Maybe folks don't even know about this rule at all. I would submit to you that's probably what's going on. There are lots of people that have no idea what's going on, and they're potentially going to become felons in just a few days. if this rule is not stopped by the federal courts. So anyway, the last option is one that has a little bit of, once again, this demonstrates the vagueness of this rule and the ambiguity of this rule. But according to I'm reading from the FAQ, which I think is the ATF's FAQs on their website, which I think is consistent with the rule itself. But there's some controversy about this, but they say you can permanently remove or alter the stabilizing brace so that it cannot be reattached, and thereby removing it from regulation as a firearm. So keep in mind what they're saying is you can remove it, but you're going to have to permanently alter it so that it can't be reattached to a firearm. Now, to me, this is not their words, this is mine. That's essentially destroy the brace is what that means. Although they don't use the word destroy. And I will say this, there are some folks, and maybe they're right. Matter of fact, I think the ATF director, what's his name? Dettelbach, I'm not sure how you pronounce it, testified in Congress 2 or 3 weeks, maybe a little more than that, a few weeks ago, said all you have to do is separate the brace from the firearm and you're good to go. You're in compliance with the rule. However, the rule itself seems to contemplate that it needs to be permanently removed and altered so that it can't be reattached. I'm just telling you what their FAQ says, what the ATF director said in congressional testimony, and I will tell you there are attorneys that disagree about, what compliance is here. I think to be safe, you're going to have to permanently alter the brace, though, if you want to take the most conservative approach to this so that it can't be reattached, if that's one of the options that you want to exercise. And of course, we would never, we can as attorneys recommend non-compliance with the law, but I suspect there are lots of folks out there who are simply not going to comply with this law that millions of us thinks unconstitutional. And that's what we're here to talk about today, to see where the courts are with regard to their evaluation of this rule.
And there are two other options, I think, options that most people won't avail themselves of, but you can turn the firearm into the local ATF office, or you can destroy the firearm entirely, which aren't really options at all for most people, but they're options that the ATF provides. But what we're going to talk about today, this is all assuming, of course, that the May 31st comes and goes, and there has been no stop to this rule. And what we're here to talk about primarily today is a case in the Fifth Circuit Court of Appeals. It's a federal circuit court. And for those of you who don't know, there are 12 circuit courts, and the federal circuit court for the United States, which is the 13th. So there are technically 13 total circuit courts, but they are intermediate courts of appeals. So there are, and I don't know the number off the top of my head, but there are numerous district courts in the federal court system, and those are the trial courts in the federal court system. Then there are circuit courts.
Can I interject, folks, so they understand what trial courts are? Those are the lowest level courts in the federal system. And with respect to this rule, there were, oh my goodness, I'm not sure how many lawsuits were filed at the federal district court level challenging the ATF's rule in this case. So that's the lowest level courts. And then the next level is, Alex talked about the 13 courts. Those are the courts of appeal at the intermediate level.
And they are called circuit courts. So if there's a decision at the trial court level, at the lowest level, the party that did not agree with the outcome can appeal the decision of the trial court to the intermediate circuit court. And then there's one more level, of course, in the federal system, the United States Supreme Court. So if there's a decision at the district court, at the circuit court, the party that's aggrieved can once again appeal one more time to the United States Supreme Court. So there was a case, Mock versus Garland, brought by the Firearms Policy Coalition with numerous plaintiffs in the Northern District Court of Texas. And in this case, they're challenging the legality of the ATF final rule. And they asked for what's called a preliminary injunction in the Northern District of Texas. And a preliminary injunction is not a final ruling or disposition on the merits of the case. A preliminary injunction is a temporary order that enjoins or stops the enforcement or the effect of the law while the case is pending. So in the Northern District, the Firearms Policy Coalition and the plaintiffs in this case, again, it's Mock versus Garland, asked the court to enjoin the enforcement of this rule. And the Northern District said, and this was a conservative judge, a judge that my understanding was appointed by George W. Bush. And he said, well, listen, I understand what you're saying, but you didn't provide me with enough information to say that you're likely to prevail on the merits, and I can't give you a preliminary injunction. So that was at the end of March, I believe, when that order came out. And the Firearms Policy Coalition filed a motion for an emergency preliminary injunction with the Fifth Circuit. So they went from the Northern District of Texas to the Fifth Circuit and said, hey, our clients and people nationwide, in fact, and this is an important point, are going to be irreparably harmed if this rule is allowed to go into effect. And not only are we likely to prevail on the merits, it's not our burden to show that. It's the government's burden, because we know from Bruin, right, that the Second Amendment confers an individual right to keep and bear arms. And it's anytime there is a law that burdens that right, it's the government's obligation, it's the government's burden to show that there is support for that law in the text, history, and tradition of our country. So here, what FPC is saying, the Firearms Policy Coalition is saying, is that, hey, we're likely to succeed on the merits. Our clients are going to be irreparably harmed, as well as other people nationwide. And for that reason, we should maintain the status quo by not enforcing this rule until the case can be heard on the merits and decided on the merits. Is that about right, Mike?
I think you've summed it up nicely. Keep in mind that there are a number. First of all, Firearms Policy Coalition, FP. What is their initials?
FPC.
FPC, great organization, a nonprofit organization. Who I won't speak for them. You can go to their website, but their primary objective is the protection and restoration of liberty, and they're involved a lot in Second Amendment litigation. So check them out and support them if you can. Number two, keep in mind there's lots of Second Amendment litigation going on. After Heller and McDonnell, which were the preeminent cases, Justice Scalia's opinion in Heller, after that is the one I'm thinking about. There wasn't a lot of litigation compared to what's happened after the Bruin decision, which was recently decided. But there's all kinds of litigation going on across the country involving the Second Amendment. Even right now, for instance, a challenge to Illinois' quote assault weapons ban. But these cases are going to take probably, and this is just my conjecture, but it's going to be this time next year before we get potential decisions from the U.S. Supreme Court, which is the ultimate arbiter of going to be the ultimate arbiter of a lot of these controversies. So in the interim, the question is, with respect to this case, should the courts allow this ATF rule to take effect and cause harm when in fact it may be essentially annulled or found to be unconstitutional in about a year? And I think there's this notion about equitable estoppel that is, I think, applicable to this situation. And what I mean by that is that and the fact that this is an arbitrary and capricious action of the ATF. And what I'm talking about there is this legal notion that the ATF has taken a position on these stabilizing braces since, let's say, 2012. And they've told us that the attachment of these stabilizing braces to a firearm does not make that firearm a short-barreled rifle. It maintains its status as a handgun. And people have relied upon that advice, those decisions, and that practice for years and years and years. That's why we have 3+ maybe 10 million, who knows how many millions of people have these things. And this notion of equitable estoppel is a principle that prevents someone or something like the ATF and the federal government from taking legal action that conflicts with its previous behavior and positions. So in this situation, I think it's absolutely appropriate for the courts to say, hey, time out. It's this status quo that we've had for 10 years. We've gotten through it. Let's keep it that way instead of just creating this huge turmoil. And let's get a decision. You may agree or disagree about how long it takes the courts to make a decision on the merits. And what we mean by that is the courts are going to hear arguments and evidence at all levels of the court system until a final decision is made. And that's really what we're saying. Hey, let's let the process play out. If the rule is good, then it'll still be good in a year. And it can be implemented then. I don't think that's going to happen, but it can be implemented then. But in the meantime, let's keep things the way they've been for the last 10 years almost.
Yeah, that's a great point, because like you said, Mike, these cases can take months, years, likely years in this situation. And people are going to be harmed in the meantime. There literally are going to be people who either register and now have a registered firearm rather than an unregistered firearm and less regulated firearm, or they're going to destroy their property potentially. So there are millions of people who fall into that category. And rather than having that harm occur, let's keep the status quo until the case is finally decided.
Yeah, and let's just wait until we get a meaningful decision.
Yeah.
We've got Bruin out there. It provides us with the guidance. It provides the district courts and the courts of appeal with the guidance they need. If they get it wrong or there's a conflict, which there probably will be, and there already is, I think, with regard to all of these decisions, then it'll play its way through the court system and the Supreme Court will ultimately weigh in, and then we'll have some stability in terms of what the law is going forward. There are folks out there that are literally going to become felons unknowingly as a result of the adoption of this rule. I mean, there's people just don't even know about it, period. And the ATF director is saying there has to be intent. Well, I'm not going to get into what the ATF director says or doesn't say, but there are going to be people that are potentially felons here, and that's great. You talk about harm, that's harm. And even if you're one of the folks that want to take advantage of the quote free end quote, it's not free. They waive a $200 tax, but I would submit to you it's far from free. Want to take advantage of registration? That is even an enormous cost. Think about the people that are going to have to go through this, and you got to go through this administrative process to ask permission from the federal government. I mean, it just is an awful notion. What if I had to ask the federal government to post something on Twitter and get a form, even if they generously waive the requirement to pay him, but I got to get permission to exercise free speech, or I have to get permission to post a sign outside my front door of my house that I'm going to invoke the protections of the Fourth Amendment. So just jumping through the hoops that the federal government's promulgated here causes harm.
Well, and I'd add to that too. Part of the reason that people purchase these firearms with pistol stabilizing braces is because they did not have to register them. Part of the value of these items is that they were non-registerable items. You did not have to register it. So by taking away that value, you're depriving millions of people of that ability to possess a firearm that does not have to be registered.
Yep. So the bottom line is, I think everybody knows what our position is on the merits here going forward, but let's let the courts do their work, leave the things the way they are right now, and this will work its way out in probably a year or less.
And a preliminary injunction, for those of you who don't know, is kind of an extraordinary form of relief. These courts are very reluctant to grant preliminary injunctions, but this is also an extraordinary law, an extraordinary rule, rather, that's taking effect and going to affect millions of people. And I think it's helpful to go through some of the requirements of a preliminary injunction. And just real quickly, but I'll also say we will link to the motions that have been filed here in Mock v. Garland. So if you want to read the motions that were filed by the Firearms Policy Coalition and also the response from the government, we will link to those in the show notes. Were you going to say something else?
Yeah, I mean, you're going to go through, I think, preliminary injunction requirements, and some of it's a little bit of lawyer talk is what it amounts to. But from my standpoint, just from a commonsensical standpoint, I think what the Supreme Court's told us in Bruin is if the government action burdens the Second Amendment right, then it's the government's duty and burden to show that there's some sort of historical analog from the founding era, 1791, that shows that these were regulated at the time of the founding, at the time of the adoption of the Second Amendment. And I don't know how, at this juncture, it's going to take a while to give the government an opportunity to try to meet that burden of proof, I think. And I don't think they'll ultimately be able to meet it. I think it's clear, in my mind at least. But just because the government passes a rule, I don't think they get a pass. The burden's on them because this clearly clearly burdens the Second Amendment right.
Yeah, that's right. And I think that's where, and the Firearms Policy Coalition pointed this out in their motion, that the Northern District of Texas erred when they said, you didn't give me enough information here to grant you an injunction. Because what Firearms Policy Coalition said is, hey, we can't prove a negative. We can't prove that there's not history to support this ATF final rule. It's not our burden. It's the government's burden to show that there is text, history, tradition to support this final rule.
Yeah, it would be like
you shifted the burden to us. It was never our burden. That's why we're asking the Fifth Circuit to grant us relief.
Yeah, it would be like I said earlier. What if the government passed a rule, no matter how unconstitutional, that said you've got to pay $200 to the government in a tax so that you can post on Twitter or whatever, social media stuff. And that went into effect immediately. And by the way, Alex, you can litigate this for the next year and find out if it's really constitutional or not. And that's essentially what's going on here in my estimation. So I think, courts generally don't want to issue preliminary injunctions. But in this case, we've got guidance from the Supreme Court that says, that provides guidance that says, the burden, you probably should issue a preliminary injunction unless the government meets the burden of showing a historical analog, or they're likely to succeed in proving an historical analog to this proposed rule.
Yeah. So we've already talked about most of these requirements to obtain a preliminary injunction. I just want to highlight them briefly. There are essentially four elements, four parts to obtaining a preliminary injunction. Number one, you have to show a strong likelihood of success on the merits. I think that's easy to do here. I think the Firearms Policy Coalition and the plaintiffs in Mock v. Garland are substantially likely to succeed on the merits for reasons we've already talked about. And number two, you have to show irreparable injury without an injunction. And we've talked about the millions of people that are going to be subject to this final rule who will suffer irreparable injury in some form if they try to comply with the rule, or even if they don't comply with the rule. I mean, frankly, they're like you said, going to become felons if they don't comply with the rule.
Yeah, and think about, and we've not mentioned, I think Maxim Defense. I'm not sure what's the exact name. One of the plaintiffs in this case. I mean, think about it, what this is doing to their business and their ability to operate as an ongoing business here. And by the way, we'll put some company out of business essentially, or potentially, I'll say. And then a year later, we'll decide, oh, sorry about that. That whole rule that put you out of business, it really wasn't even lawful.
Yeah. But an important point here to make too, based on, with respect to your comment there, Mike, is that the Firearms Policy Coalition is not requesting an injunction only with respect to the named plaintiffs in this case. They're requesting a nationwide injunction because of the nature of this final rule. The plaintiffs are not the only ones affected by the final rule. Number three, that the balance of hardships supports an injunction. What hardship is there by not granting the injunction? I can't think of one. That the government can't get people to register their firearms. Is that the hardship? I don't know.
It's sort of, and this sounds awful, but it's part. I guess it's part of the ongoing desire of the federal government to get us all to bow to their wishes. I think that's the biggest that's the hardship maybe on the federal government if they don't get to continue that. But anyway,
So
I mean, I could come up with some arguments. I mean, they might say these are dangerous weapons, and that I don't know. Well, I don't know what we'll leave that to the federal government to come up with whatever.
I'll link to the government's response to the request for a preliminary injunction in the show notes, and I did read it, but it frankly doesn't make any sense. They basically said, hey, this rule doesn't even implicate the Second Amendment. It doesn't burden the right because these aren't bearable arms, and it was really just
they're trying to say they're trying to say it's a tax. It's the same reason the NFA was passed in the beginning. It was a tax. Mm-hmm. That's the way they got it through, but that's another historical story. But they're basically saying this is just a common regulation, and that's why I'm highlighting, hey, what if you had to pay $200 to exercise your right to free speech? People wouldn't stand for that, and the Supreme Court said the Second Amendment is not a second-class right. Yeah. So, I mean, think about that. All you folks out there that have a Twitter or Facebook, if you had to take, first of all, you had to send out or fill out some long application, send the government $200. Of course, they're waiving it in this instance, I understand, but then you had to wait 9 months, a year for the government to get back with you and say, oh yeah, it's okay. You can go ahead and talk now if you want.
Yeah. Yeah. And what if we said Twitter is a platform for high capacity speech or assault speech? I mean, it's just absurd. And you have to pay a tax because you could say things that are mean and dangerous and unusual.
Yeah.
I mean, there is a movement to do that sort of thing.
Yeah.
But
yeah, there definitely is. And there has been previously. Yeah. The government's evidently, that's another story, seen fit to regulate what's going on Twitter. And
let's stomp out the 3x all the speech that doesn't comply with the 3x5 card of allowable opinion. I'm taking a note there from Tom Woods. So anyway, we've got one more part here to the preliminary injunction. We've talked about number one, the strong likelihood of success on the merits. Number two, irreparable injury without an injunction. Number three, the balance of hardship supports an injunction. I think 1 through 3 are all clearly in favor of the plaintiffs here. And number 4, finally, that the public interest favors such relief. And I think, again, clearly number 4 weighs in favor of the plaintiffs and weighs in favor of granting a preliminary injunction because, like we said, it maintains the status quo. It maintains the way that things have been for the last 10 years based on the ATF guidance before the final rule. And it prevents the harm that would be caused to millions of people if the final rule goes into, or it's already in effect, but once we get beyond the amnesty period on May 31st.
Yeah, and I never say always, I suppose, but I can't think of an instance now where I don't think it's in the public interest to curb agency authority and say, hey, let's make sure that they actually have this authority under the law.
So one other thing, you mentioned equitable estoppel. One other notion or legal doctrine I'd like to mention is the rule of lenity, which basically says if you're a baseball fan, the tie goes to the runner. So if there's an ambiguity in the law, the interpretation goes against the drafter. So here, the drafter was Congress. Congress made the law. ATF is interpreting the law. They've interpreted the law saying that these pistol stabilizing braces on these firearms do not constitute NFA items for the last 10 years. And then now they've changed it to say, well, actually, it does constitute an NFA item. And they've done that because of this ambiguity in the law. And where the law is ambiguous, the tie goes to the runner. That's the rule of lenity, essentially. So I think that's an important doctrine to mention. But the other thing I'd like to mention before we close up here, Mike, is that the Firearms Policy Coalition in Mock v. Garland has asked for this emergency request for an injunction to take effect May 24th. So that's, I think, Wednesday of this coming week. So keep an eye out for that. I don't know what the chances are, what the odds are of an injunction coming from the Fifth Circuit, but I think it would be fairly good. And this is kind of a last-ditch effort to stop this rule from taking full effect on May 31st.
Yeah, obviously. I mean, I have no idea I don't want to give odds on it, but all I would say is just my opinion. I feel better about an injunction, a favorable injunction being issued today, more than I did a week ago when we were talking about this. So, and reading the briefs, we'll see. Hopefully, by the way, this circuit has been very favorable to this and predisposed to recognizing that the Second Amendment is not a second-class right, as the Supreme Court has indicated. So that gives me more hope than anything. That something will come out of this week. The other thing is, for those of you who have just been kind of waiting to see what happens and thinking about registration through the e-form process, this maybe the court will make a decision, and then if you want to go that route, you'll have time to do something after the court issues a decision in this particular case. But last thing I'll mention is, you hear some people talk about, didn't Congress do something? Congress is not going to do anything. All your congressmen do is they get on it. Here, I'm going to get on my soapbox a little bit, but they're going to say the right things, and they're going to say what you want to hear, and they're going to do nothing ultimately. That's what's going to come out of Congress with respect to this. Now, if the Senate's taken over by the Republicans, the House stays Republican, and you get a Republican president, maybe something will happen. Although I will remind you that we had the House, the Senate, and Donald Trump the first 2 years, and
That got us the bump stock ban.
yeah. So I don't have great hope for the politicians. They usually talk the loudest when they know their talk won't mean anything ultimately. So anyway, I'm on a soapbox. Our hope here for this week is with the Firearms Policy Coalition. Those are the people that are going to be the heroes here if they can get something done, not your local congressman or senator or whatever.
Okay, so I think that's a good place to close up the show for now. Mike, thanks again for joining us for Monday Gun Day. As you probably noticed, Mike is a regular guest on Monday Gun Day, and I'm sure he'll be back in the near future. So I hope to have him as a regular guest for this segment of the show. So thanks again for tuning in. Like I said, check out the show notes if you have more interest in the briefs that have been filed in this case, and keep an eye out for that May 24th deadline. Hopefully the court gives us a favorable ruling on that date. If you enjoyed the show, don't forget to give it a thumbs up and subscribe to help spread the message of freedom. Sunday, I'll be releasing an episode with a former prosecutor and current judge about the theory of retributive justice. So keep a lookout for that episode. It should be interesting and informative. Until then, remember, you are the forge of freedom.